Welcome to the Diary of a Lawyer.
The Diary of a Lawyer and all its content published is strictly for educational and informational purposes only. Nothing presented here constitutes legal, medical, or mental health advice, nor does it create an attorney-client relationship and does not constitute professional advice. Please be sure to consult with a qualified professional in your jurisdiction regarding your personal situation for advice that is tailored to your specific situation.
We always lead with that really robust legal disclaimer because, well, today's deep dive centers entirely on the legal frameworks that govern literally your daily existence.
Yeah, the invisible architecture of your digital life, basically.
Exactly. I mean, every single time you open a browser or, authenticate an app or even just allow your mobile device to connect to like a public Wi-Fi node, you are triggering this massive cascade of legally binding agreements.
Right, and most people have absolutely no idea it's happening.
None at all. So we are dissecting the architecture of digital consent today. The general data protection regulation and those invisible data supply chains operating right beneath the surface of the web.
Which is a huge topic.
It is. And you know the scenario. You navigate to a site, and before the page even fully loads, before the text is even there, a window hijacks the screen. It's the ubiquitous cookie banner.
Oh yeah, the classic accept all button.
Right. A brightly colored massive accept all button that completely dominates the screen, while this tiny muted low contrast link offers the illusion of, managing preferences.
Illusion is definitely the right word there.
And what do? You bypass it. You click accept, operating on pure muscle memory because you just need to access the content behind the wall, right?
Exactly. And that friction, the interruption of your task, is intentionally designed by UI engineers to trigger that exact behavioral reflex. You just swat it away like a fly.
Like a pop-up from the 90s.
Right. But the legal and technical execution of that single click is just staggering. I mean, in the 100 milliseconds it takes for that banner to disappear, you have executed a microcontract.
Wait, a legally binding contract just from clicking a green button?
Oh, absolutely. You have authorized the website to read and write state maintenance mechanisms to your local hardware.
Okay, unpack that. State maintenance mechanisms.
Cookies, trackers, pixels. Basically, you've just triggered real-time bidding protocols that immediately broadcast your behavioral vector.
My behavioral vector. That sounds incredibly dystopian.
Well, it is. It's your location, your device fingerprint, your operating system, your browsing history, and it broadcasts all of that to hundreds of third-party ad exchanges simultaneously.
Wow. All in the time it takes the banner to close.
Yeah. The algorithmic option concludes the ad is served to your screen, and your data is persistently stored in these disparate server farms all over the world, all before you have even read the headline of the article you came for.
That is just... It's wild to think about.
Yeah.
And that real-time bidding broadcast is the mechanism we really need to isolate today.
Definitely.
Because we often talk about data collection as if, a company is just sitting there taking notes in a ledger book.
Right, like some guy with a clipboard.
Exactly. But the reality of modern ad tech is this highly synchronized, completely automated commodities market. And your behavioral surplus, your data, is the asset being traded.
And for a really long time, there was absolutely no regulatory friction to slow that market down. None.
The Wild West.
Total Wild West.
Yeah.
If we look at the internet ecosystem prior to May 2018, it was characterized by an almost complete absence of data provenance. I mean, ad networks, data brokers, massive tech conglomerates, they were scraping, compiling, and trading user data with structural impunity.
They could just do whatever they wanted.
Pretty much. The user was entirely abstracted from the transaction. You were the product, but you had zero say in how you were sold.
So pre-2018, what was the actual legal justification for this?
Yeah.
'Cause they must have had something.
Well, the prevailing doctrine of the pre-2018 web was essentially this concept of notice and consent, but it was executed in the most legally superficial way imaginable.
You mean those massive terms of service documents?
Exactly. A company would host a 15,000-word terms of service document written at like a postgraduate reading level, link it in tiny font at the absolute bottom of their webpage, and then argue that by merely loading the site's HTML, literally just visiting the page, you had given implied irrevocable consent to limitless data extraction.
That is absurd. Just visiting the site implies consent to a 15,000-word document.
It was a total legal fiction. The entire digital economy was built on this unreadable, non-negotiable contract of adhesion. You couldn't negotiate it. You couldn't opt out.
So that brings us to the GDPR.
Right. The introduction of the General Data Protection Regulation, the GDPR, was the European Union's attempt to fundamentally dismantle that specific legal fiction.
And the intent wasn't just to, like, add a layer of annoying compliance paperwork, right?
No, no. It was an ontological shift in how the law views digital identity. It was about moving the locus of control from the processor, the big tech company, back to the natural person, back to you, the listener.
Okay, so the core of that shift really relies on redefining what actually constitutes personal data. Because I think um, the baseline assumption for a long time, and frankly, what I always thought, was that privacy laws only protected direct identifiers.
Like what?
Like, a passport number, a social security number, a primary email address, banking credentials, things that blatantly say, this is who I am.
Right, the obvious stuff.
But when I hear that this includes an IP address or a
Yeah.
browsing preference, that feels like a huge stretch. I mean, how is my screen resolution personal data?
It's a great question, and it's because the ad tech industry doesn't actually need to know your government name to monetize you. They don't care if your name is John Smith.
They just care about what I buy.
Exactly. They rely on probabilistic identification. So if they have your IP address, your screen resolution, the specific battery depletion rate of your device.
Wait, battery depletion rate? They track how fast my phone battery dies.
Oh, absolutely. That is a highly unique metric. If they combine that with the custom fonts installed on your machine, they can construct a unique device fingerprint.
Wow. So I'm essentially carrying a unique barcode just based on my device setting.
Precisely. And the GDPR's brilliance, specifically in recital 26 of the text, is that it accounts for this. It explicitly states that data is personal if it can identify a natural person, directly or indirectly, through any means reasonably likely to be used.
Reasonably likely to be used. That's an interesting
No,
phrase.
it's the operational linchpin of the whole law. The law acknowledges that an IP address sitting alone on a server might not inherently identify you.
Right, because it just points to a router, technically.
Yeah.
Yeah.
But if an entity has the technical capability and, crucially, the commercial incentive to combine that IP address with cross-site tracking scripts to isolate your specific household, then that IP address is elevated to the status of protected personal data.
So it's about the context and the capability of the company holding the data.
Exactly. The law looks at the aggregate capability of the processor. It recognizes that in a surveillance capitalist model, anonymity is just a statistical impossibility when enough disparate data points are merged together.
Okay, so this expansive definition is why the legal perimeter of the GDPR encompasses almost all digital activity, regardless of whether a user has explicitly created an account or, logged into a service.
Right. You don't need to be logged into Facebook for Facebook to process your personal data.
That's intense. And that legal perimeter isn't just bound by physical geography either, which I think was the true shockwave to the global tech industry back in 2018.
Oh, the extraterritoriality. Yeah, Article 3 of the regulation establishes this.
Right. So explain how that works for our listeners, because it's an EU law, but it affects everyone.
So you do not need to be a European company with servers sitting in Frankfurt to fall under its jurisdiction.
Right.
If a, let's say, a software startup based in Silicon Valley deploys analytics trackers on their app, and a user sitting in a cafe in Paris opens that app, just opens it, that Silicon Valley startup is now actively processing the data of a data subject within the Union. Boom! They are subject to the GDPR.
So the European Union essentially exported its privacy framework globally by just leveraging the sheer size and economic power of its consumer market.
Exactly. If you want access to European consumers, which everybody does, you play by European data rules, period.
And the enforcement mechanism backing that extraterritoriality is what actually forced these multinational corporations to comply, right? Because before this, they were just absorbing regulatory fines as a standard cost of doing business.
Oh, totally. Prior data protection frameworks had these statutory maximum fines that were essentially rounding errors for major tech firms.
Right, like a speeding ticket for a billionaire.
Exactly. I mean, a 500,000 euro fine for a company generating $1 billion a quarter, it offers zero deterrent effect. They probably make that much in the time it takes to rate the check.
So how did the GDPR change that math?
The GDPR fundamentally altered the risk calculus by tying the maximum administrative fine directly to global corporate revenue.
Global revenue.
Yes, specifically up to 20 million euros, or 4% of the total worldwide annual turnover of the preceding financial year, whichever is higher.
Okay, we really need to analyze the specific phrasing there, because you said total worldwide annual turnover of the undertaking.
Yeah.
They didn't say the profit of the local subsidiary.
No, they absolutely did not.
Right, so let me use an analogy here. Let's say a global conglomerate sets up a tiny little shell company in Ireland to handle their European data processing. And that specific shell company violates the law.
A very common setup, by the way.
Right. So the regulator doesn't just calculate the fine based on the shell company's revenue, do they?
No, they pierce the corporate veil. They look right past that shell company. They look at the global consolidated revenue of the entire parent conglomerate.
So if a tech giant does $100 billion in gross revenue globally, they're looking at a potential $4 billion penalty.
Exactly. 4 billion with a B.
That is massive. That transforms a localized compliance issue into a catastrophic board-level existential threat.
Which was exactly the point. It forces privacy engineering to become a foundational architectural requirement, rather than just an afterthought delegated to the legal department like 3 days before a product launch.
Right. Hey, legal, can you rubber stamp this?
Yeah, that doesn't fly anymore. Companies suddenly had to actually map their data flows. They had to understand exactly where data was coming from, where it was stored, who had access to it, and crucially, under what legal basis they were holding it.
And for the vast majority of web interactions, that legal basis hinges entirely on the deployment of cookies and tracking pixels.
Which brings us to the actual battleground.
Right. This is the practical battlefield where the theoretical weight of the GDPR collides with the daily reality of the user interface.
The cookie jar.
The cookie jar. So to really understand that battlefield, we need to strip away the abstractions and look at the technical reality of state maintenance mechanisms. So what actually is a cookie?
Define it simply, right. The web fundamentally is built on the HTTP protocol, which is stateless.
Meaning it has amnesia.
Yes, perfect way to put it. When you click a link to move from a home page to a product page, the server has no inherent memory of your previous action. It treats every single request as a brand new user.
Which would make things like online shopping impossible.
Completely impossible. You'd add a pair of shoes to your cart, click to go to checkout, and your cart would be empty. So cookies were originally engineered in the 1990s as a vital utility to solve this amnesia.
Okay.
They are just small text files, data payloads, written to your local machine so the server can maintain continuity. Keeping your authentication token active so you don't have to log in on every single page. Remembering the items in your shopping cart. Ensuring the basic functionality of a session.
And the legal framework recognizes the necessity of that architectural function, right?
It does, and this is why we have a clear bifurcation in how tracking technologies are regulated. The e-privacy directive, which works in tandem with the GDPR, often called the cookie law, establishes that if a tracker is strictly necessary for the provision of an information society service explicitly requested by the user, consent is not required.
Okay, so you do not need to ask permission to drop a session cookie that holds a user's shopping cart state.
Right, because the user inherently requested that functionality by adding the item to the cart. You literally cannot fulfill the user's request without it. So the law says, go ahead, that's fine.
But, and there's always a but with the ad tech industry.
Always.
The industry is incredibly adept at stretching legal definitions.
That's an art form for them.
Right. We are seeing companies attempt to classify highly invasive telemetry as strictly necessary. They will argue that dropping a fingerprinting script is strictly necessary for, fraud prevention or server load balancing.
Yes. They tried to bundle diagnostic data extraction into the essential functionality of the site to bypass the consent requirement entirely. It creates this massive gray area where structural engineering just completely overlaps with behavioral surveillance.
And regulators aren't just letting that slide, are they?
No. Regulators have had to aggressively push back against this semantic expansion. The European Data Protection Board, the EDPB, has issued very strict guidance, limiting the scope of strictly necessary.
What's the line they draw?
Basically, if a cookie is used to analyze the performance of a website, what we typically call analytics cookies, that is not strictly necessary for the user.
Wait, really? Even just Google Analytics?
Even just analytics. It is highly beneficial for the website owner to know which pages are rendering slowly or which buttons are driving engagement, sure, but the user did not explicitly request that analysis.
Okay, that makes sense. I didn't ask you to track my mouse movement.
Exactly. Therefore, performance and analytics tracking requires affirmative consent.
Okay, so we've got strictly necessary, which requires no consent. We have performance and analytics, which do. Then there's functional cookies, right?
Yeah, functional cookies remember user choices. Like if you select English as your preferred language or your region for weather updates, again, you need consent for those if they aren't strictly essential to the core service.
But the real monster here, the one that drives the multi-billion-dollar industry.
The targeting and advertising cookies.
Yes, the moment you move away from the strictly necessary infrastructure, you enter the realm of the behavioral mosaic. And this is where the creep factor comes in.
Oh, everyone knows the creep factor.
Right, think about the analogy of physical surveillance. If strictly necessary tracking is like giving the valet the keys to park your car, right? It's essential for the service. Targeting cookies are like the valet secretly following you home, looking through your windows to see what kind of shoes you like, and then selling that information to a shoe store down the street.
That is exactly what it is. If we use a retail analogy, it's like a barcode invisibly stamped on your back. As you walk out of one store and enter a completely different mall, security guards scan your barcode, note how long you looked at a pair of sneakers, log your demographic profile, and then instantly auction that route map off to the stores you haven't even visited yet.
Which is terrifying.
And by the time you walk into the third store, the displays have physically rearranged themselves based on the highest bidder's prediction of your purchasing intent. That is the literal digital reality of third-party targeting.
And that precise reality is what makes the acquisition of user consent so critical and, frankly, so heavily manipulated. Because the ad tech ecosystem relies on maximum data velocity.
Yes.
The requirement to pause that velocity, stop the user, and ask for explicit informed permission threatens the fundamental economics of their entire model.
It's an existential threat to them. If a user is presented with a neutral, objective choice to participate in a persistent cross-site surveillance network, the empirical data shows that a massive percentage will decline.
Right. Who would voluntarily say yes to that if they really understood it?
Almost nobody. So faced with this reality, the industry deployed dark patterns.
Dark patterns. This is where psychology meets UI design, right?
Exactly. Systematic UI and UX designs engineered specifically to subvert user autonomy.
Let's unpack the psychology there. Because a good cookie policy is clear. It lists the third parties and it's easy to manage. But dark patterns are entirely about the strategic application of friction.
Friction is the key word.
Right. The design goal is to create asymmetric effort. A legally compliant interface would present two buttons of equal weight, size, and color. Accept all and reject all.
Right, perfectly balanced.
But that creates equal friction. So instead, platforms engineer a path of least resistance. The accept action is frictionless. A single click on a vibrant, heavily weighted, usually green or blue button.
Right. And the reject action.
It's intentionally obscured. It's hidden behind a manage preferences hyperlink that opens a secondary modal. And that modal is usually filled with dozens of toggle switches, often utilizing deliberately confusing double negatives.
Oh, the double negatives drive me crazy. Slide this to off if you do not want us to stop processing your data.
Yes, or pre-checked legitimate interest objections that require manual granular deselection for literally hundreds of vendors.
They weaponize cognitive load. That's what it's called. The user is attempting to complete a primary task, right? Reading an article, buying a plane ticket. The consent modal is an obstacle to that task.
An annoying roadblock.
Exactly. And by making the privacy-preserving choice require 15 seconds of concentrated cognitive effort, and the privacy-invading choice require a tenth of a second, the interface forces the user to trade their data for convenience.
Just to get it out of the way.
Yes. And this isn't just poor design, let's be clear. It is a calculated legal strategy to extract consent through exhaustion.
Wow. Consent through exhaustion. And that brings us directly to the core of GDPR enforcement, because the law actually has very specific definitions of what constitutes a valid legal agreement.
Right. Under the GDPR, a tricked yes or an exhausted yes is legally identical to a no.
Okay, let's dissect the four pillars of true consent. Article 7 and Article 411 of the GDPR. It defines consent as any freely given, specific, informed, and unambiguous indication of the user's wishes.
And those four criteria are not guidelines. They are strict legal prerequisites. If a company's UI fails on even one of those criteria, the entire data processing operation becomes unlawful.
Okay, let's look at the first requirement, freely given. How does the law interpret freedom in a digital landscape where one company might monopolize the service you need?
Freely given is perhaps the most heavily litigated element of the entire regulation. For consent to be truly free, the user must have genuine objective choice and control. There can be no coercion, no intimidation, or significant negative consequences for refusing.
Okay, so what if a site says, accept our cookies or you can't read our articles at all?
Right, that's what we call a strict cookie wall, a mechanism where a website blocks all access to its content unless the user accepts behavioral tracking.
Is that legal?
No, European data protection authorities, or DPOs, have consistently ruled that if access to a service is made strictly conditional upon consenting to data processing that is not actually necessary for the performance of that contract, the consent is coerced.
Because you're penalizing the user for exercising their fundamental rights.
Exactly. You can't hold the content hostage for data that you don't strictly need to deliver the content.
But wait, we're seeing a massive evolution of this right now with the pay or okay model currently sweeping across European media sites.
Oh, yes. The new loophole.
Right. You go to a news publisher and the model says you have two choices. Accept all behavioral tracking cookies so we can monetize you through ad exchanges, or pay a monthly subscription fee of €5 to access the site without tracking.
Right. They argue they are offering a free choice. You don't have to give us your data, just give us your money.
But privacy advocates like Max Schrems and his organization NOYB, they argue that placing a financial penalty on privacy means the consent is not freely given. It literally commodifies a fundamental human right.
Yeah, the regulatory bodies across Europe are actively clashing over this interpretation as we speak. The tension there is profound. You have the fundamental right to data protection colliding directly with the freedom to conduct a business.
So where is it landing?
Well, the EDPB has signaled that while pay or okay isn't strictly banned in all circumstances, the alternative offered cannot be prohibitively expensive. And crucially, the power dynamic between the platform and the user must be balanced.
So if a dominant gatekeeper with a functional monopoly demands you pay or be tracked, the power imbalance renders the consent invalid.
Exactly. A small blog might get away with it, but Meta, probably not.
Okay, so that's freely given. This seamlessly connects to the second strict requirement.
Yes.
The consent must be specific.
Yes. This is the death of the bundled contract.
So no more blanket I agree to everything buttons.
Exactly. A company cannot present a monolithic agreement that says, I consent to the use of cookies. The interface must disaggregate the purposes.
Break it down for me.
So if the company wants to use analytics to measure site traffic, that is purpose A. If they want to use tracking pixels to retarget you with ads on a separate social network, that is purpose B.
You know, the user have to be able to choose.
The user must have the granular capability to accept A while rejecting B. The UI cannot force a binary all-or-nothing proposition.
Okay, granularity is essential. And I guess that directly supports the third requirement, informed. Because a user cannot give specific consent if they don't actually comprehend the architecture of the processing.
Exactly. Informed requires transparency that pierces through legal abstraction. It has to be in clear, plain language.
So no more postgraduate legalese.
Right. The controller must disclose their identity, the specific purposes of the processing, the type of data collected, and crucially, the existence of the right to withdraw consent.
What if a company relies on a vague statement like, we use data to improve your experience? We see that everywhere.
They fail the informed test. Improving an experience could mean fixing a broken link, or it could mean training a generative AI model on your private messages.
Right, completely different universes.
The ambiguity is legally fatal.
Legally fatal. I love that phrasing. And that legal fatality was established quite explicitly in cases dealing with the fourth requirement, unambiguous.
The affirmative action requirement.
Right. The consent must be an affirmative, positive action. For years, the industry relied on implicit consent. They would place a banner that said, by continuing to use this site, or by scrolling down this page, you agree to our use of cookies.
Or they would use pre-ticked checkboxes on a checkout page. Uncheck this box if you don't want our newsletter, that kind of thing.
But the Court of Justice of the European Union obliterated this practice, right? In the landmark Planet 49 case.
Yes, Planet 49 was huge. The court ruled unequivocally that silence, pre-ticked boxes, or inactivity do not constitute consent.
So scrolling past a notice legally does not count.
Does not count. There must be an active, deliberate intervention by the user to say yes.
The Planet 49 ruling was a watershed moment because it formalized that requirement for active engagement. And it ties directly into the ongoing requirement of that engagement, which is governed by Article 7.3, the right to withdraw.
Ah, yes. The hardest thing to find on the internet.
Truly, the regulation mandates that withdrawing consent must be just as easy as giving it.
This is an architectural mandate. If a website utilizes a one-click persistent banner on the homepage to acquire consent, they cannot bury the revocation mechanism deep within a third-tier settings menu.
But that is incredibly rare to find. I mean, websites almost never follow this rule.
And that's why DPAs like the UK's ICO or France's CNIL are actively levying fines over this exact issue right now. The friction to opt out must be completely symmetrical to the friction to opt in.
Symmetrical friction, which, from an engineering standpoint, is why you are increasingly seeing those persistent, floating little privacy preference widgets anchored to the corner of compliant websites.
Exactly. They look like little paper clips or gears floating in the bottom left corner.
Right. They know that if they hide the withdrawal mechanism, they are exposing themselves to regulatory audits.
And we should briefly note here, just for clarity, that consent is only one of 6 lawful bases under the GDPR.
Right, there are others, like legal obligation or contract performance.
Yeah, but consent is the primary one for cookies. And if we're talking about sensitive data like health information, race, political or religious beliefs, sexual orientation, that requires an even higher bar: explicit consent.
Explicit consent. So not just yes, but a documented, highly verified yes.
Exactly. But for all this focus on consent, we really have to look at the macro strategies of the big platforms.
Because technology didn't stop evolving in 2018.
No, it accelerated. The dominant tech monopolies recognized that relying on user consent for behavioral advertising was a massive structural vulnerability.
Because if the law requires an easy no, millions of users will click no.
Right. So they attempted an incredibly audacious legal maneuver to bypass the consent requirement entirely.
This brings us to the most consequential legal battle of the post-GDPR era, the showdown between European regulators and Meta.
A fascinating case study.
Truly. To understand the gravity of this, we have to look back at Article 6 of the GDPR, which you just mentioned outlines the 6 lawful bases for processing personal data.
Yeah.
And another lawful basis, besides consent, is performance of a contract.
Yes. If you order a physical product online, the vendor does not need a cookie banner to process your home address. Processing that data is strictly necessary to fulfill the contract of delivering the product.
Right. The data processing is inextricably linked to the service you requested. You can't have the shoes delivered without giving them your address.
Exactly.
So Meta looked at that legal basis and engineered a spectacular pivot. In the lead up to the GDPR coming into force, they altered their terms of service. They essentially argued that users were not signing up for a standard social network.
Right. They changed the definition of what they were offering.
They claimed that the core contractual service they provided was a personalized, behaviorally targeted advertising experience, interspersed with social content.
It's just such a brazen argument.
It really is. Therefore, they argued, tracking users across the web to build behavioral profiles was not an optional add-on requiring consent. It was strictly necessary for the performance of their contract with the user.
It was an attempt to fundamentally redefine the legal nature of a digital platform. They tried to elevate behavioral surveillance from an ancillary monetization strategy to the core contractual obligation.
You signed up to be surveilled.
Basically, if this legal fiction had been accepted, it would have effectively neutered the GDPR for any ad-funded service. Every platform would simply rewrite their terms to state that being tracked is the service.
So what happened? Did the regulators buy it?
Well, the Irish Data Protection Commission, which acts as the lead supervisory authority for Meta in Europe because Meta's HQ is in Dublin, they initially engaged with this argument, which led to years of protracted legal and procedural warfare.
The structural dynamics of that warfare are fascinating.
Yeah.
Because of the GDPR's one-stop-shop mechanism, the Irish DPC is the primary regulator. But the GDPR also has a consistency mechanism, right?
Yes. If other European regulators feel the lead authority is being too lenient, they can object.
And that is exactly what happened. The German, French, and Austrian regulators looked at the Irish DPC's handling of this meta-contract argument and basically said, absolutely not. They triggered a massive dispute resolution process at the European Data Protection Board.
And the EDPB ultimately issued a binding decision that was just a devastating blow to Meta's legal architecture. They ruled unequivocally that behavioral advertising is not an objectively core element of a social media service.
Because you can run a functional social network without tracking a user's cross-site browsing history.
Exactly. Chronological feeds existed long before personalized ads. Therefore, Meta could not rely on contract performance to force beta processing upon its users.
And the EDPB instructed the Irish DPC to strike down this legal basis and levy massive fines.
Hundreds of millions of euros in fines. It forced Meta to change how it operates across Europe.
And I want to emphasize why this matters to the listener. This isn't just dry legal theory. This proves that European regulators can actually force multi-billion-dollar companies to change the digital products that billions of people use daily.
It proved the law had teeth. But the platform didn't just surrender. The agility of their legal strategy is genuinely remarkable.
Oh, they pivoted immediately.
The second contract performance was invalidated, they pivoted to another lawful basis: legitimate interest.
Okay, explain that one.
The GDPR allows companies to process data without consent if they have a legitimate interest that is not overridden by the fundamental rights of the user.
That's a balancing test.
Right. So Meta argued that their legitimate interest in running a profitable ad network outweighed the user's right to privacy.
And how did that go for them?
Once again, the regulatory hammer came down. The Court of Justice of the European Union eventually ruled that personalized advertising cannot justify the processing of massive volumes of user data under the guise of legitimate interest without explicit consent.
The user's fundamental rights take absolute precedence in that balancing test.
Yes. And this relentless regulatory pressure is what finally forced Meta in late 2023 to fundamentally alter its European infrastructure and pivot to that highly controversial pay or consent model we discussed earlier.
This multi-year saga with Meta perfectly illustrates the transition into what legal scholars are calling the omnibus era. Because the EU realized that relying solely on the GDPR, a law focused purely on data protection, was insufficient to curb the structural power of tech monopolies.
Right. The GDPR is foundational, but it's not enough on its own anymore, especially with AI and massive data marketplaces emerging.
They needed to move beyond regulating how data is processed and start regulating the market mechanics of the platforms themselves.
Which led to the deployment of the GDPR omnibus and the digital package.
Right. Omnibus isn't a single law.
No, it's an evolving ecosystem of legislation built on top of the GDPR foundation. You have the Digital Services Act, the Data Act, the AI Act, and crucially the Digital Markets Act, or DMA.
Let's talk about the DMA because it introduces this really critical concept of the gatekeeper.
Yes, the DMA targets the gatekeepers. A gatekeeper is a core platform service, like a dominant search engine, a major app store, or a massive social network that serves as an inescapable gateway between businesses and consumers.
Like Apple, Google, Meta, Amazon.
Exactly. And the DMA applies ex-ante regulation to them.
Ex-ante, meaning before the fact.
Right. Instead of waiting for a gatekeeper to abuse their market position and then fining them retroactively after years of litigation, the DMA explicitly bans certain behaviors outright.
What kind of behaviors?
Crucially, the DMA strictly prohibits gatekeepers from combining personal data collected from their core platform service with personal data collected from any of their other services or from third-party websites.
Unless they get consent.
Exactly. Unless the user has been presented with a specific, explicit choice and has granted consent under the strict definitions of the GDPR.
This is a surgical strike against the mega platform business model.
It completely disrupts it.
Because if you are a gatekeeper operating a video platform, a search engine, and an ad network, you can no longer seamlessly merge the data profiles from those three distinct properties to create an omniscient behavioral mosaic.
Right. They can't just pool everything into one giant profile anymore. The DMA forces a structural separation of data silos unless the user actively permits the merger.
It is an attempt to inject friction into the back-end operations of monopolies, mirroring the friction they have historically forced upon the user via dark patterns.
It's poetic justice in a way. It fundamentally reshapes the architecture of compliance. We are moving from a regime of reactive privacy policies to proactive structural engineering.
But, and this is the big pivot for our listeners, while this massive geopolitical battle plays out between Brussels and Silicon Valley, the actual execution of these rights still cascades down to the individual user.
Right. The regulators are fighting the gatekeepers at the macro level, but what can you do at the micro level on your own device right now?
The legal frameworks exist, the enforcement mechanisms are active, but the daily burden of managing digital autonomy remains largely on the shoulders of the data subject. You.
Which requires us to transition to actionable takeaways. How do you take back control? The legislation provides a toolkit, but those tools are entirely inert unless you actively wield them.
Step 1. The 15-second habit.
Yes, stop clicking accept all.
It's altering user behavior to leverage the legal architecture. We have to address the cognitive fatigue of consent management.
It's annoying, I know. But taking that extra 15 seconds to actively click Manage Preferences and disable tracking cookies is not just an exercise in digital hygiene. It genuinely disrupts behavioral profiling.
How much of an impact does one person clicking reject actually have?
A lot. When a user actively rejects a tracking cookie, they're not merely shielding a single browsing session, they are injecting decay into their long-term behavioral profile.
Decay. Because the algorithm loses the thread.
Exactly. Ad tech algorithms rely on recency and continuity. If a profile goes dark across a significant percentage of a user's web activity because they are consistently rejecting third-party trackers, the statistical confidence of that profile
The
degrades.
predictive models fail.
The value of that specific behavioral asset plummets. Widespread, habitual rejection of consent mechanically starves the surveillance infrastructure.
That's incredibly empowering. But what happens when a user encounters an infrastructure that refuses to accept that rejection? When they hit a dark pattern that illegally hides the opt-out mechanism?
That's step 2, reporting violations. If a site hides the reject button, report it.
But doesn't that require a lawyer?
Not at all. The legislation provides a direct line to enforcement. Article 77 of the GDPR guarantees the right to lodge a complaint with a supervisory authority. This is a critical, often underutilized weapon.
Because data protection authorities are not passive entities?
No, they are highly resourced investigative bodies that rely heavily on user reports to identify systemic noncompliance. DPAs like the ICO, CNIL, BFDI, the DPC, they all have highly streamlined, accessible online digital intake portals for everyday people.
So if a platform is utilizing forced consent or deploying a manipulative UI, a user can just take a screenshot.
A simple screenshot and a brief contextual report submitted to a DPA can trigger a preliminary inquiry. Regulators utilize these reports to establish patterns of behavior, and those patterns are the prerequisites for initiating the large-scale audits that result in multi-million euro administrative fines.
It's crowdsourced regulatory intelligence.
Exactly.
Okay, step 3. This is my favorite one. Subject access requests, or SARs.
Oh, this is the superpower.
It really is. It's the most potent, visceral tool granted to the individual. It's found in Article 15, the right of access. Dive into this superpower for us.
Under Article 15, any data subject, any user, has the right to obtain confirmation as to whether personal data concerning them is being processed.
And if so,
And if so, they can demand access to that specific data, the purposes of the processing, the categories of data involved, and the specific recipients to whom the data has been shared.
you can just ask a company what they have on you.
Yes. And the law mandates that the controller must provide a copy of the personal data undergoing processing within 1 month, free of charge.
How hard is that for a company to actually do?
The operational reality of a subject access request is a profound shock to most organizations. From an engineering perspective, it is a monumental task.
Because the data isn't just sitting in one neat little folder.
Never. A single user's data might be fragmented across AWS servers, third-party marketing SaaS platforms, localized CRM databases, legacy backup systems. Fulfilling in SAR requires the organization to have mapped their entire data ecosystem with absolute precision.
It weaponizes transparency.
It really does.
Yep.
If you submit NSAR to a data broker or a major platform, the resulting payload is often hundreds of pages of raw, serialized telemetry.
It moves the concept of surveillance from abstract theory to undeniable, terrifyingly specific reality.
You see the exact timestamps of your location, the granular categorization of your perceived psychological traits, the specific algorithmic assumptions made about your financial stability.
And submitting these requests forces the platform to expend significant administrative resources to prove their compliance, which acts as a massive deterrent against reckless data accumulation.
Which leads to step 4, essentially a warning for businesses. 2018 compliance is no longer enough.
You can't just set up a cookie banner and forget about it.
No. Regular reviews with data protection professionals are mandatory. Because of this internal friction-like fulfilling SARs, the regulation mandates the appointment of a data protection officer, a DPO, for organizations engaging in large-scale systematic monitoring.
So what does a DPO actually do?
If a company is required to have one, they must utilize them effectively. The DPO is a legally protected, independent entity within the corporate structure. They cannot be penalized for executing their tasks, and they must report directly to the highest management level.
They are the internal regulator.
Exactly. The bridge between the engineering teams building the tracking architecture and the legal mandates of the GDPR. A failure to empower the DPO is viewed by regulators as a systemic failure of accountability.
Okay, so to summarize, the entire ecosystem we've dissected today in this deep dive, from the granular definition of an IP address to the massive fines levied against gatekeepers, from the psychology of dark patterns to the architectural nightmare of fulfilling a subject access request, it is all a testament to a fundamental recalibration of power.
A massive shift.
We are witnessing the slow, agonizing transition of the internet from a lawless extraction engine into a regulated utility where individual autonomy is a legally enforceable right.
And the foundational takeaway here is that data protection law is not merely a compliance checklist for corporations. The GDPR exists to put you back in control of your digital self. It is a defensive architecture for the individual.
But the legal mechanisms are robust only if they are used. They require engagement.
Right. Because the algorithms governing the digital economy are designed to optimize for passivity. They rely on the assumption that the friction of defending your rights will ultimately override your desire to exercise them.
Which leads us analyzing the future trajectory of this arms race. I mean, the current paradigm places the immense cognitive load of negotiating these legal boundaries entirely on you, the user, 50 times a day, click by exhausting click.
Which isn't sustainable.
It's not.
Yeah.
But as the omnibus era matures, we are seeing the genesis of technological countermeasures. I want to leave you with a final provocative thought to ponder.
Oh, I like where this is going.
With the burden of constantly managing preferences falling on the individual, will we eventually see the rise of AI assistants or new browser-level technologies that automatically negotiate consent on our behalf?
Essentially fighting the corporate algorithms with our own personal privacy algorithms.
Exactly. The emergence of legally binding browser-level signals like global privacy control points to a near future where the negotiation is automated.
Imagine a protocol where your user agent automatically broadcasts a legally enforceable object processing signal to every server it contacts.
Forcing the ad tech architecture to drop its trackers before the page even begins to render.
We are moving toward an inflection point where we no longer fight algorithmic surveillance with manual exhaustion.
Right. We'll deploy our own automated, legally backed algorithms to defend the perimeter of our digital economy. Stay safe and curious out there, and we will see you in the next episode.